with the roll call from the Director of Zoning, Eric, Mark, you call the roll call for us?
Sure will. Murphy? Here. Haynes?
Here.
Matthews?
Yes.
Philippe?
Yes.
And Long.
Here.
We have an agenda for us tonight, but we have, besides the board members, we have Julie Donnan, legal counsel, and Eric Moore, Director of Zoning here. And we'll proceed to the agenda. Old business, we have none at this point. New business, approval of the meeting minutes from February 19th, 2026. Has everyone had a chance to review those minutes that were previously sent out to everybody?
Yep. Yes.
I want to ask if there are any corrections, deletions, or additions to the minutes. If there are no corrections, deletions, or additions, the minutes stand approved. No formal vote will be required for this. I thank you, Mr. Grace. All right, now let's go into the second agenda item, which is the extension of CU 2501 and V 2501 5409 Woodville Court. And that they have made a request to extend both for 12 months with a new expiration date of 9/18/2027. Mr. Moore, would you like to?
Sure.
Proceed with that?
So, in your packet, I've included the request letter. Asking for an extension for an additional 12 months for the conditional use, as well as the variance that was approved in September of 2025. The permit is expected, it's set to expire on the September 18th, 2026. They are asking for an extension for an additional 12 months so that they can allow them time to obtain a certificate of zoning compliance and building permits for the property. Also in the packet is the actual conditional use in the variance that was previously approved, as well as the staff report that was reviewed and the minutes from that meeting where it was discussed and approved.
I have a question on this, and I had thought I had read that that property might have been sold, but as far as we know, is this same Joshua
Yes.
Fromm and his or legal counsel representing him?
Correct.
Is that, or is the approved variance or the conditional use permit transferable?
And I just can't remember. Well, the variance is transferable. Conditional use depends on what your zoning resolution says. The default, if it's silent, then it would stay with the land.
Okay.
And I think here. And board procedurally, it is not uncommon for applicants to request extensions, you know, for
Yeah.
one thing or another.
Representative Henry Timms, I make a motion that we take this before vote to approve or deny the extension. Second that motion?
One more question for Julie. You said this
this is not out of the ordinary for this to happen. Just with regular development of sites.
Yeah, it just depends on, a lot of, developers need to get their zoning locked down pretty early on in the process. And there are other things, engineering and other development items that have to take place before they can start, putting shovels in the ground, which in turn leads to the certificate of zoning compliance. So yeah, it's not uncommon.
Okay. Okay.
Things to be needed. The purpose and goal is just to make sure that, 10 years go by and nothing happens, the township at least has some backstop.
Sounds like a plan. I'll second your motion to vote on it.
I made a motion to take it to floor vote.
Okay, motion to approve the extension for conditional use 2501 and variance 25-015409 Woodville Court. Motion made by Haynes, seconded by Matthews.
Lawford.
Lawford.
First name Matthews. First name Smith.
All right. Murphy. Haynes.
Yes.
Matthews.
Yes.
Philippe.
Yes. Yes.
Approved. Third item on the agenda is discuss allowing the authority of zoning director to extend without board approval, such as this extension that we just did.
So, that request is made, this is the second one that I've received. And I just, would like to propose that I would be permitted to do that. I think if there were changes, something like that, we would have to come back, of course, in front of the board to make those. But if it's just, I need more time, just like this, I'd just like the authority to be able to say, yep, you can extend it, I can send them a notification and say, yep. I don't know if we want to put a time frame on it, 12 months, that would be the max. Anything over that, then we need to go back to the board on.
So, and it would require an amendment to the zoning resolution, which another agenda topic. We are getting a zoning amendment in order, so this is something that if the BZA was comfortable, we can address that in the zoning amendment. But basically, just as Eric said, and again, there can be limitations on it. Perhaps, the first extension, Eric has the authority to give. If someone needs another extension, then maybe at that point, they come back to the board, but just to give some flexibility, since this is, as Eric said, come up twice now. There could be a situation, again, you were supposed to meet this month anyways because of our training, but if you hadn't would have had to basically haul you guys out for the extension as the only agenda item. So, again, and as part of all of that, we're gearing up for an amendment to the zoning resolution anyway, so, if the BZA would be comfortable having Eric have the authority to sign off, that would be fine. One thing to also keep in mind, I can't even think of a scenario where I would advise Eric to deny a request for an initial extension, but, if he were to deny, that is an action that the applicant could appeal up to you anyways. So that's kind of the check and balance on Eric's authority, if you were to be comfortable with what we've proposed.
Sidebar question, you probably should ask before we vote on the last one. Is there additional fees for the extension for the continuations? Okay. Okay.
Do we have any questions for Eric on the subject?
So that fee was on that one, that was the last fee.
Correct.
Okay, that was just,
That was just
that was the initial.
Correct.
Okay, got it.
I just put it there for reference, so you could refresh your memories to what you approved.
And how
And it has nothing to do with you. I have tremendous respect in your ability, your knowledge, your integrity. But it has to do with, if we grant this, then in this situation, is it setting a precedence? And that was the number one thing, and behind that precedence was a little bit what she alluded to, was your own liability. That you're taking the liability away from the board, away from these people, and accepting that and going forward. And I'm concerned about that for you or any individual that was sitting in your chair. And that's just those two people. If you can give me some comfort in that.
So I think, what I would say is Eric there's a variety of administrative authority that Eric already has that you folks don't even see because it just would never end up in the BZA pipeline. I do think that, this is a little bit of a square peg round hole, having the extension come to you because again, you're charged with approving or denying applications, and this isn't really either of that. So, what I would say is, obviously, any amendment isn't permanent, and if there were a situation where, not Eric, maybe Eric's successor or someone is abusing their authority or maybe acting in a way they didn't want to, that sort of thing, the process could be amended back. I'm not necessarily overly concerned about increased liability. Again, if someone were to deny the initial request, the applicant does have a mechanism to get in front of you.
What about a notification to the BSA that they requested an extension? Because if Eric just okays it, or Eric's title okays it, then we should at least know that, they're extending it again, they're extending it again. So,
But that's one of the placeholders you had in there. It can only be extended once before it comes back in front of the board, correct? Or is that what you mentioned beforehand?
So it could be set up
A possibility, I
any
should
number
say.
of ways, but, again, if you wanted to limit the zoning inspector's authority, to basically look, first one, zoning inspector has the ability to extend. Any other requests after that have to come to the board. We could set it up that way. We certainly could include a notice requirement, basically that,
If there's no application for an extension, it's just a letter.
Yeah.
Okay. It's like, hey, we just need more time.
Yep.
Mr. Murphy, you have any thoughts about that?
In construction projects and things like this size especially, there's gonna be extensions, it's necessary, so I have no problem with Eric.
We want to put it to a floor vote?
Well, and we don't need a vote, just kind of a consensus. If there's a consensus that, again, maybe the first, Eric gets the first go, and then after that, it would, with the first go and provide notice to the board, any additional extensions would have to go
And this would have to be presented to the trustees to be voted on and written in, correct?
Yes, in
Okay.
terms of, so just getting, and we've got another agenda topic that we're looking for consensus from you folks. So, but we get consensus from you in terms of process. I'm working on an amendment to the zoning resolution for some other things. Part of that will now include an amendment to 815.45, which deals with expiration. That will go to the zoning commission for a hearing. That will go, and then after that, it'll go to the trustees for a hearing. And then if the trustees vote to approve, it'll become part of the zoning resolution.
There's still paperwork and time involved with that, even for Eric to, not, lack of a better term, rubber stamp something for a continuation on stuff.
Yep.
Should there be an additional fee, even if it is $100 for a continuation?
That could be added. you'd have to update the fee schedule, but an extension, a permit extension, yeah.
Put that in there, so I've got, notifying the BCA that an extension was requested and approved if we move forward that way. Only extended one time, and that would be up to a 12-month period. Any additional requests for, extensions would be, in front of the board, BCA. And then possibly adding an extension.
Well, we wouldn't see this one for 2 years, probably, because it's 27, right? No, yeah.
It expires in 26, so it'd be 12 months from, so it's 12 months from September,
Yeah.
from 27.
That'd be good. I don't have a problem.
Apply to-
Fee is good because you're spending time on that, so maybe a small amount when compared to the application.
The way this is written, Ms. Julie.
And this is the current language.
Right,
The-
right.
Yeah, okay.
Right. So, the 1-year extension, is that from the previous expiration date or from the date that we just approved it now?
So the way pardon me. I would take the position, and what they requested was 1 year from the date of the
Okay.
original approval.
Because they added in that additional date. If they didn't add in additional, that'd be it.
That could be a little tricky. Yep, it could be a little tricky.
Okay. So maybe that needs to be clarified too for future. All right, I'm good unless anyone else got anything else.
I'm fine with Eric doing it.
Appreciate it. We will take this feedback to the zoning commission.
Thank you.
How does that increase or decrease your workload if this goes through?
On the second one, so.
Okay. What about Julie?
Well, and that's exactly it.
Right.
You know, realistically, it'll probably stay about the same for us, but you don't have to decrease because we wouldn't have to be at a meeting. But no, makes sense. It makes administrative sense just to.
Absolutely. Okay.
Appreciate it.
The next item on the agenda is the Board of Zoning Appeals training.
All right. Well, I will try to, I generally, this is about an hour, but I think since you gentlemen have, I think you've all heard this. It's been a few years, but I think you've all sat through this presentation, again, at least a couple of years ago. If there are any specific questions or, again, just feel free to just ask them, you know. I think I'll hit on a few things that may be good refresher. I mean, part of this, again, it's the goal is also refresher, since you guys have been operating for a while, you've been on the BZA for a while. In terms of starting point, and I'll start just high level, and I won't spend too much time on kind of the what is zoning. But in terms of your zoning resolution, it consists of, you know, the text, which is in front of us, and a map, which outlines what every property in Blendon Township is zoned, what district it's zoned to. You know, zoning is an exercise of police power. It is the government regulating personal property. It's real estate, not personal property, but real property. And because it is a police power, there are potential constitutional issues that can arise. and, with respect to the township's ability to zone. And, the township has to narrowly craft and tailor its zoning regulations, because again, if you do it wrong, you're depriving someone of the right to use their property, which can be big constitutional issues. In terms of, we talked about a zoning amendment that's gonna go through, here shortly. That is a legislative function. So the zoning commission and the board of trustees, they act in a legislative capacity. They act like Congress or the General Assembly in terms of, and a zoning amendment is like a bill that is introduced, down at the State House. Their operations, they can act, people can lobby them. Applicants or property owners can have private conversations with the trustees or the zoning commission. Can't be a quorum of those bodies, but they can have offline conversations about the zoning text and possible amendments and possible rezonings, that type of thing, because it's a legislative function. And at the heart of that, that's a lobbying. That's almost like lobbying. In terms of the trustees' hearings and the zoning commission's hearings, they are much less informal than yours. They do not have to take sworn testimony. They can take opinion. Again, it's, I think that if we rezone or if we amend the text, it will have a negative impact because X, Y, and Z. I don't have any evidence to that necessarily, or I might not have any evidence to that. I just think it's my opinion. And the zoning commission of the trustees find that opinion compelling, then they may agree with you. You folks, BZA, serve in a quasi-judicial capacity. You serve a variety of functions. Some of those functions include interpretation, for example. And I don't think you guys have you had an appeal? No. Okay. So and I'm really jumping out of order right now, but that's okay. We'll talk about that. So, and I mentioned earlier that theoretically, if Eric were to deny someone, and he makes a decision, and that person says, "I think Eric got it wrong," they can appeal Eric's decision to you to hear. And that situation would be very different than the other hearings that you've had, where, again, it's Eric gives a staff report, and then the applicant kind of tells you what's going on. In that situation, in an appeal situation, it's like a mini trial, basically. It is the person who's appealing, they have to put on their case of why Eric got it wrong. Eric would then have the ability to rebut that. And I can give you a couple examples of appeals that I've seen actually next week. I'm dealing with a continuation of one, but basically somebody the zoning inspector issued a violation notice because they're operating a trucking business out of their home. Like, well, it's not a home occupation. You live in a residential district. You're also operating a business out of the back. And so the zoning inspector issued a zoning violation, and the property owner filed an appeal, and so had a hearing in front of the BZA, and said their argument as to why they thought that the zoning inspector got it wrong. Appeals are, again, infrequent. You guys that is, I think, consistent with the fact that you guys haven't seen it. Appeals can be quite contentious, quite frankly. Appeals can just be contentious. I'll leave it at that.
The appeals wouldn't be here, they would be in a courtroom.
No, it would come to you. So you would be the first step. So basically, if Eric renders a decision and someone thinks Eric got it wrong, they have 20 days from the date Eric makes that decision to submit basically a request saying like, I want to appeal his decision. We would get a hearing set up, and so the board would hear the decision, or hear the, whether or not Eric got it right or wrong, make a decision, and then your decision, if the person who appealed, if you basically upheld Eric's decision, the person who appealed could, they're upset, I think the BZA got it wrong because you thought Eric got, they could appeal your decision to the Court of Common Pleas.
And that's where we would go to court.
Correct, exactly. And we'll get all of the applications and all of the hearings that you see and decide on could end up in common pleas. We'll talk about that a little bit later. But yeah, so that's kind of what appeals look like. It's really a mini trial. In those types of situations, it just is a little different.
Would that be, in case of that happening, would that be a separate day from a regular meeting, or that would be scheduled during a regular meeting, and then we handle normal business?
Yep. It'd just be
As
another
well.
agenda item. So instead of,
Okay.
you might have, a couple conditional uses, you could have other applications before or after, but yeah. So, in terms of what things that you hear and see, you get appeals based on, administrative decisions from the township, conditional uses, and variances. In terms of conditional uses, I know you guys have seen a few, obviously. Just as a kind of global reminder, when the zoning commission and trustees set up the zoning resolution, every district has permitted uses, which by right, you can use your property, if you're zoned that district, you can use your property for any permitted use. But your zoning resolution also identifies conditional uses, which are uses that, in putting together the legislative document, the trustees have decided, we think there are situations where these uses could work, but maybe there are situations where they won't work. It could be fact specific. And so they want it to be a conditional use, so that way the BZA hears evidence and testimony about what someone may want to do, and you, in using your judgment, if you think that they've provided evidence as to, that makes sense and it's appropriate, you can approve it. Conditional uses are unique in that, and we've had this discussion before, that theoretically an application could meet all of the criteria of a conditional use, but there are situations where the BZA can still deny. So again, there's nothing nothing's guaranteed. Any questions about conditional uses?
Is there a time limit somebody could bring
Oh.
appeal before you?
Oh, an appeal, of basically like an appeal of Eric's decision? Yes, so someone has 20 days after Eric makes a decision to appeal. So if Eric tells me, hey, Julie, your property's in violation because you have a fence that is too high, and I don't do anything for more than 20 days, I've lost the right to appeal to you. So there is a time period. And I think your zoning violations, your formal zoning violations include information about the right to appeal and that sort of
That's
thing.
just the application for the appeal, that's not our meeting.
Correct, yes,
So
yep,
They just have to
yep,
put it in within 20 days.
exactly, yep. So, and obviously the good part about that, or the reason that there's kind of a backstop is you don't have all of these like potential appeals lying in wait. People have to move. Once the zoning inspector renders a decision, they have to decide whether or not they want to appeal that. So there's some time certainty for the township.
Speaking of the timeline,
Mhm.
going back to what we were talking about before with the continuation process, Eric denies, they have 20 days to appeal. What if they waited until like the last day they could,
Mhm.
before the extension so that's a 30-day period. What
Oh, I hear-
what
I hear
happens
ya.
if there's overlap?
So, what I would say, so those are basically those are kind of two different timelines.
Okay.
Because the extension, I think they have to request it within 30 days before the expiration of the 1-year period.
Right.
So if they were to make that request on, I mean, and there could be multiple things that someone's appealing. Again, someone could appeal the fact that, I hear what you're saying, but I think that there is still the scenario that it doesn't matter if the timeline has expired. I think there's some sort of reservation.
Okay,
right?
I just wanna make sure
But
that we're not.
That's fair, because they are different or potentially different timelines. No, I think that's a fair question. In terms of variances, there are two types of variances, use variances and area variances. And that is because each district contains standards that are use standards and area standards. Use standards are just that. What can you use your property for? Area standards are more what can you do on the property itself? You know, what are the setback lines? What are the setback distances, building heights, open space requirements, that type of thing. There are two very different standards for use and area variances. For use variances, the standard is unnecessary hardship, which is incredibly high and almost difficult to achieve. Because the law disfavors use variances, because really what you need to do is rezone your property if you want to use it in a way that's not appropriate in the district that you're in. It is a very high standard. Practical difficulties is area variances. Unnecessary hardship, the property owner can't have created the harm, can't be an act of self-harm. They have to have no other economically viable use for their property. It is a very, very incredibly high standard, and they have to meet all of the standards for unnecessary hardship. That's use variances. Area variances, the standard is different. It is practical difficulties. Sometimes I've been in a few BZAs recently where they reference hardship for an area variance, and that's not the case. It is practical difficulties, and I know you guys are very familiar with the Duncan factors, and as I know we've talked about, in order for an area variance to be granted, they don't have to meet all of the factors. You don't have to consider all of them. It is, again, in terms of, again, it's a practical difficulty. Is there something that's going on their property that makes it difficult for them to do something that they want to do and they can't? And again, the standard is much lower because there's less at stake in terms of the use, as opposed to a use versus when we're talking about what's like the structures and that sort of thing on the property. There is a fourth item that the BCA reviews. I don't think you will ever experience this, but basically the BCA does have the ability to hear, to revoke conditional use permits granted for surface mining. And I don't know that you guys are ever gonna experience that. So again, appeals, variances, and conditional uses, I think, are the.
Don't catch anybody peeing for gold down Long Creek over there. Yeah.
So somebody salts the land with gold or something like that.
There you go. Something then like we've got a very interesting situation. In terms of protecting how you run your hearings is important for protecting the decisions that you make, and in turn, if someone appeals your decision, to come and please. And because you're quasi-judicial, because your hearings need to be much more formal than zoning commission or the trustees, again, the goal is, or not the goal, but you have to do some certain things in order to protect your decision down the line. In terms of those hearing formalities, I know you guys are great about doing that. Swearing people in, has to be sworn testimony. They have to provide evidence, not opinion. I know that sometimes, that's not what you get, but sometimes, again, at the end of the day, it is supposed to be evidence, not opinion. Whereas the zoning commission and trustees can hear anybody talk about whatever, technically the only evidence and testimony that you should receive is from the applicant and any party in interest, which is basically adjacent property owners or anyone who could experience a unique harm from if the application's approved.
Or if they have legal representation, correct?
Or if they've got legal representation. What I would say, and especially for, I don't know how you determine in the middle of a hearing if someone has standing, and so our advice is generally let people speak. You can figure out based on their address and their testimony, quite frankly, of whether or not.
We've heard people talk about a property that they're all the way across the way, but they're talking about, but that is.
Exactly.
But that person that was putting in the property or something had come and
I lived here 5
and
years
been
ago,
in
I
their
love how the
property,
trees
but
grow.
that has nothing to do with the property we're talking about, so.
And that's exactly it,
Yeah.
like, okay, somebody gets up and you might not know when they start speaking, but as you hear the
Figure it
address,
out,
you hear the
it's cool.
context, and you're like, oh, you're not, and again,
So, can we tell that person to sit down? No, probably not.
I would with extreme caution.
Yeah.
And kind of turning to some other kind of crowd control topics. Another difference, you folks do not have the ability to set time limits for people speaking. However, in terms of crowd control, and I think you guys do this in your kind of rule, or your kind of operating guidelines, you say, listen, please try not to repeat yourself. If there's information that you agree with, or other information that if the same information as your neighbor, you're welcome to say that, but please try to stay focused. What I will say, again, if people get off topic, and I think you guys are also good at that, if people get off topic, at some point, like, okay, but we're talking about this application. Again, what are we talking about here? It doesn't matter that you're upset that their tree's about to fall down. They're here requesting a home occupation, conditional use for a home occupation. So again, those are just in terms of crowd control, some things to keep in mind. I'm thinking through a few things just things that haven't come up for you guys. Yes, yeah.
So with Franklin County, and somebody's gonna build, and I remember we had a case of a person who wanted to put their building in basically the front yard. Okay, we call that. And we asked a ton of questions about the building, okay? And I don't know necessarily that those were relevant to us, at all. I mean, you need to make an assumption that, well, that's between you and Franklin County. And we asked, how many windows you gonna have, how many doors you gonna have, are you gonna have this? But it really had no, other than emotional, it wasn't even a part of the discussion.
Yeah.
Yeah.
And it is easy for that to happen. And I get it that it's, what I would say is, one, try not to, try to, at some point, if the conversation has veered off, refocusing and saying, wait a minute, like at the end of the day, we're here, the application is for a setback issue. Doesn't matter how many windows are.
I started doing that, and
Yep.
I said this to Eric, that I started questioning Eric at the podium. And we hadn't did that before, but it wasn't about me. It was, I wanted to make sure that it was a little bit, that understood what the scope was here,
Yes.
what we're talking about.
Yes.
Not,
And what I would say, so another key, and I think that goes towards building your record. All of your meetings are recorded. If there's something particularly contentious, it's been a while, which is good, but if it's something that's been particularly contentious or where there's been a concern, look, this could be appealed. You guys have had a court reporter come out. Because, again, for part of the, if your decision does end up getting appealed to common pleas, the township does have to produce a transcript of your hearing. And if you don't, again, we'll get to that in terms of like, well, what happens if that doesn't happen? We'll get to that. But in terms of kind of preparing the record, walking through, and if anyone were to, what you just described of asking those questions of Eric or of the applicant of, what are we really talking about here? What is the application really about? That helps protect the board if the applicant doesn't like whatever your decision is. That helps protect you that, like, the board talked about what they were considering, and even though there's something that's contentious or not, something else going on the property people don't like, once again, the board said on the record, it doesn't matter. We don't care, like, we're not talking about those things. Members of the audience, doesn't matter that you don't like those things. So I think I think that is something to keep in mind of, again, I think it's protecting your record, protecting the board's discussion of what was the board doing in the hearing, and that sort of thing. So I think that's fair. What I would say, and it's easy when Eric gives the staff report and I don't know that you guys do this, but I've seen other boards start to ask questions of the zoning inspector that and someone's like, it's like, what, applicant, these are you questions, not necessarily Eric questions. Excuse me, but no, I think that is important. That's a good question. Some other hearing components, something I don't think you've seen, but so applicants do have the right to cross-examine, and so it only happens when something's particularly contentious, and usually it's an attorney who's cross-examining, but just something to keep in mind, since you haven't seen it, someday that could arise where, the public starts, giving their testimony, and the applicant or applicant's counsel could say, well, I want to ask you some more, I want to ask that person more questions. To basically pull apart their testimony. I'll give you an example of where I've seen that. A resident came up to a board, was hearing an application, and residents started talking about property values. And if you approve this, this is going to hurt our property values, da-da-da-da. Well, the applicant's attorney goes, and are you, what is your background? Are you professionally involved in real estate at all? Are you an appraiser? Are you a realtor? Are you, what is, like, and that goes towards, this is just your opinion. At the end of the day, this is your opinion that this will hurt property values. It is not a statement of fact or based on my professional know-how and knowledge. And so the attorney, by cross-examining, really pulled through, or, pulled out that this wasn't actually testimony, that this would hurt property values. What it was just an opinion. So, again, I would suspect that I would be at whatever if and when that happens, I'd suspect I would be at that meeting. But again, since you haven't seen it, I just wanted to at least mention that to you.
What would happen if the person that was being cross-examined refused to answer?
So the DCA actually has the ability to compel. You have the ability to subpoena people. They're sworn under oath. But at the end of the day, are you guys gonna, call Chief Belford to come down? Realistically, if someone were asked a question and they refused to answer it, I think our advice would potentially that,
Okay.
of like, you know, we'll note for the record they refused. I don't know that I've ever seen someone refuse before, but that is a good question, especially like, it only happens in, again, cross-examination happens only in contentious situations. I'm gonna give that a bit more thought of like what, yeah. No, it's always good to like be prepared if someone decides to like throw up. So yeah, no, that's a good question. I'll give that a bit more thought. But yeah, I think,
Okay.
I would probably take the position, like, you are giving testimony under oath in front of, like, you signed up for this. You signed up. You're giving
Yes, you
testimony.
volunteered.
You volunteered.
Okay.
But no, that's a fair point. The risk, again, all of the risk of that person refusing or that sort of thing, it provides the applicant with an opportunity. Again, it could potentially impact your decision, which again, I keep saying that, pushing down we will talk about all of these things put together in terms of protecting from an appeal and that sort of thing. I have not been going through this, so I want to make sure, I'm going to pause for a second and make sure. I would agree. So something, I think you have, I don't know if we've seen this before. So we've had this come up, so because you're quasi-judicial, when you make a decision, and if you were to deny an application, there is a concept called res judicata at play, which prevents someone from basically saying, well, I'm just gonna refile, you know, in 2 years, you know, I'm gonna hope that a couple of you are no longer on the board and I'm gonna ask for the same thing. Because you make judicial decisions, quasi-judicial decisions, applicants are prohibited from refiling the same application unless there's been a change in circumstance. Let me think of an example.
Kind of like a criminal double jeopardy.
That's exactly it. You can't ask for the same thing twice. And I can't think of a situation. Again, I'm thinking of like fences and all that sort of thing.
You can't just say we're going to paint it blue rather than brown.
Exactly. There needs to be something different, and it's difficult to. It obviously depends on whether or not there actually has been a change in circumstance, but that's something to keep in mind. We've started to see this a little bit of where someone submits an application and they kind of just request multiple continuances, or they, you know, just kind of goes to the zoning inspector, and so it's a situation where, all right, well, the BZA has this application, we've got a hearing scheduled, but if you deny the application, they can't come back and refile. So what do you do? We've had that situation start to pop up a bit more, and something, I don't think you have this in your rules and regulations, but it might be something we want to revisit at some point. We have started putting language in rules and regs for BZAs that basically says, if we have to continue your application at least twice, then the board reserves the right to dismiss for lack of prosecution. And the applicant can come back and refile. They'd have to pay the fees, they'd have to do all of that, but at least it gets you out of a scenario where if you have to make a decision, yes or no, on an application where there's no one here presenting evidence, I think the only answer is no.
That happened to us.
We've already had that, yeah.
Mm-hmm.
Okay, you guys did.
Yeah.
You did, yeah.
And it was no.
And it was no, and it was no.
I don't even remember because there was nobody here to present evidence.
Yeah,
Oh, we had that workshop, yeah.
yeah, we had that.
Now that you mentioned that, well, it's happening in other places, so, so
I mean,
that.
those were easier cases for
That
us.
is true. Like, you couldn't be bothered. Something we've gotten, this is kind of this one comes out of the blue every once in a while. So, after the BZA makes its decision, there is the ability for the BZA to, quote, reconsider its decision. So you render a decision, you say, nope, we're not approving X, Y, or Z. You have the ability to reconsider that decision between the time you take action and once the appeal period, 30-day appeal period runs. Why would you do that? And it's, again, it's a very rare circumstance. I have.
But does there need to be an appeal to do that?
No. It could be, realistically, what I've seen is, the applicant makes an argument that there was like a due process issue. That like, I didn't have enough time before the hearing, or I don't, I've also seen if there's like additional evidence or information that has come to light, and it's like, listen, this was something that the board expressed interest in, we didn't have it, we now have this information. It is very rare for, one, to get a request for reconsideration, but it's also rare for the BZA to actually, agree to do one. I actually have a BZA that they got a request and the board is basically like, no one's willing to call a special meeting and so it's like, well, that's your answer. Nobody's gonna call a special meeting for it, so board's not gonna reconsider. And again, that's how it should be. It should be used sparsely because you don't want a situation where applicants think that they can just ask you to reconsider instead of going through the appeal process. It's like, no, you need to come to the board, BZA prepared and ready to go.
Mom, Dad said I can't go to the party, what do you think?
Exactly. So, I'm going to, want to tie some things together in terms of, I talked about protecting your decision to prepare for an appeal. So because you're quasi-judicial, your decisions are subject to what we call 2506 administrative appeal. And 2506 is a section of the revised code that deals with not just BZA, but basically any administrative appeal. And I'm trying to think how to say this. If you follow if you have your hearing and meet the standards that are set forth in 2506, things like sworn testimony, a transcript, allowing the applicant to be in person represented by counsel, allowing the applicant the opportunity to cross-examine, that type of thing, those formal hearing requirements. And the board makes a decision while following those formal hearing requirements. If an appeal happens, the judge has to look at the transcript and decide, based on the testimony, based on the evidence, was it reasonable for the board to act the way and make a decision the way they did? It is not saying whether you got it right, whether the judge thinks, I don't think that's the right argument, they should have gone with this argument. It truly is like, was it reasonable? Was there information and evidence that the board could rely on to make this decision? And again, you follow all those processes and procedures. They can't that's what they're limited to reviewing.
Is it just the transcript, or is it like the YouTube recording?
It's the transcript and then any exhibits that might have been submitted.
Okay.
But no, it wouldn't be the YouTube, the video. If you don't follow those, hearing requirements, if you don't get sworn testimony, if you don't swear people in, if you're not able to produce a transcript, you tell the applicant you can't cross-examine people. If your decision gets appealed, the judge has the ability to, what we call open the record, and basically the judge will have a whole new hearing. And so they're like, all right, well, we're doing it all again. Like, everybody, instead of being in Blended Township, we're gonna go down to Franklin County, I'm the judge, I'm gonna hold this hearing, and I'm gonna hear the information evidence, and I'm gonna make the decision. I don't care what the BZA did. So again, because Blended Township wants to make decisions for Blended Township and not have, Franklin County judges make those decisions on your behalf, that's why all of those pieces are so important. It's all to protect your decision and make sure that whatever you do decide stands if it's ever challenged. Moving through this, which is good. I will touch on, the last thing to touch on is conflicts of interest and ethical considerations, and I think
On
that,
page 12,
Yeah.
under 3,
yes.
it says the appealing party was refused the opportunity to use this as subpoena.
Yes.
So they can use this as
So the Board of Zoning Appeals has the ability to issue subpoenas. So if the applicant were to say, if the applicant wanted testimony or
they said, "No, we
documents,
don't want it."
and they said, board, we'd like, so-and-so wouldn't come of their own volition to this hearing. Will you please subpoena them so that I can get testimony out of them? And the BZA were to say, no, we're not gonna do that. That is another thing that they could, again, when they appeal your decision, they're gonna get in front of the judge, and the judge is saying, all right, we're having a hold-in hearing. So yeah,
Is there a
that's,
cost to that, or is there, how's the subpoena, is that, is that just, we have to go through the.
there's
township?
probably, I would call them soft costs, because realistically what would happen is you'd have one of your police officers, our office would draft the subpoena, have the chair sign, and
Okay.
then one of your police officers would deliver it to the person being
And then
subpoenaed.
we would continue the hearing at another time with that person coming in.
Yep. That is also a very rare,
I know, that's good.
I'm trying to think, I think we did,
But I could see how easy.
It's obviously happened.
yeah.
But I could see how easy it was. It's like, no, we don't want to hear that guy. It's like, just don't.
Yeah, or,
I could see that, where we would say that. It's like, but we really can't say that, so.
someone,
if they're requesting it.
seen situations where, in an appeal, where someone came contesting, zoning inspector said I'm using, it's a use violation, and I'm using my property different, or in a way that's incorrect, and it became clear that and the property's owned by husband and wife, and it became clear the wife wasn't involved, but it was the husband who was, but the husband wasn't there, and the BZA did not subpoena the husband, but, in my mind, I was like, subpoena him, but they decided not to. They did not subpoena and drag the husband in, but yeah, you're exactly right, of people could play games and not show up.
Is there, side question, is there a limitation of time from when the meeting starts? Because once we ask that, or if they're gonna be testifying, that they sign the book up there at the thing. And what if someone would happen to walk in a couple minutes late, not be on the book? Is that a problem per se?
If someone were to walk in, my advice would be let them speak, even though, again, things happen. The risk is someone walks in late and the township says, nope, you didn't show up on the right time, you haven't, nope, we're not gonna let you speak. That is, if they're a party in interest, if they have standing of some sort, they could appeal your decision.
We have to try to make accommodations.
Exactly.
Okay.
I think it's just a good idea. Again, what's the
We
harm?
do pretty good about asking people to sign in and
Yeah,
and
yeah.
swearing them back in if they are late, so, yeah.
In terms of, and I think you guys you've had at least one continuance. You've had a hearing, yeah.
That property that we're just talking about.
Yes, yep. So something to keep in mind, and if you had to subpoena somebody, if you had to do all those things,
Well, we only have to subpoena if somebody asks us to do that.
correct. Or the board could,
We don't really-
if you wanted to, but I don't know, I can't think of a situation where you
Why
would
would we
want
want
that. Exactly.
The applicant is saying, well, my neighbor really likes me to do this, or whatever, but neighbor's not in the audience.
Correct. So, and part of the reason is.
Longer for us.
Right. No, I know.
Yeah, but something to also, in terms of like, what's the point, or what's the purpose of the ability to compel people to come in? Because it has to be evidence, and someone in that situation, you know, my neighbor said X, Y, and Z. Well, the neighbor isn't here to give that testimony. The neighbor can't be cross-examined. We're just taking you at your word. It's hearsay. And so those are situations where that could put your position at risk if the BZA were to say, well, we believe that guy that his neighbor said X, Y, and Z, you know, and a party of interest could say, well, it wasn't based on evidence. You know, that wasn't based on, you didn't cross-examine the neighbor, you know, so the neighbor didn't give that under oath.
We need to be aware of that.
So things you need to be aware of.
Does anybody have the right to appeal?
No. So again, only parties in interest, adjacent property owners, and people who have a unique harm. So the same people who have the ability, who have to be able to speak, they have the ability to appeal. Again, you get far more people who want to speak, but they wouldn't actually appeal. But sometimes it does. Sometimes neighbors do appeal decisions if something's particularly contentious. Let me think. Any additional questions about kind of hearing process, 2506, thoughts? Okay.
You do a pretty good job if things come up to answer questions for us
Yeah,
during the meeting.
I mean, they're pretty straightforward. It looks like a lot of that stuff we do. So.
Yes, and that's exactly why I wasn't going step by step, because you guys already practice a lot of what's in here.
I'm not seeing too much you don't.
Yeah, no, I would agree. Just a friendly reminder, you are subject to the Ohio ethics laws. In terms of zoning decisions or zoning actions, how that, you know, kind of comes into play. If you receive notice of something before the board, you need to recuse yourself. So if you're within, you know, X number of feet or whatever, you need to recuse yourself. If an application comes in front of the board that involves you, your immediate family, or your business associates, you need to recuse yourself. And recusal is not just, I'm gonna abstain from voting. Recusal is truly, you know, I'm not involved in discussions, I'm not involved in private deliberations, I am not
Move
here.
yourself from the seat, sit out there for that portion of the meeting?
So that is a common question, and what I will say is, well, you don't have to truly remove yourself, but I always pose the question of, and know thyself, I know some people who can't help themselves. If they're sitting here, they're gonna ask a
Writing notes,
question.
texting you while you're back there, yeah.
And they can't help themselves. And so what I would say is, if you can't help yourself, sit in the audience. Sit in the audience. The other thing to keep in mind is, and you guys have not had this happen, the zoning commission, wait a minute, I'm getting things confused. Yeah, zoning commission's had somebody recuse themselves, right? Maybe I've got my wires crossed. I might have my wires crossed.
But I can't remember what it was about.
But anyways, you know, the fact that you serve on this board, doesn't mean that you serve on this board, but you are also a resident in this township, and so.
Gray lines, a neighbor. Oh, Matt lives across the street from me.
You lucky guy.
I went bankrupt, I had to move that to someplace. But, you know, or my friend, you know, where do those fall?
So, in addition to family, yourself, your business associates, if an application is in front of the board that could be a benefit or detriment to your property, so again, if it's a neighbor,
Yeah.
that that would be something that it's appropriate to recuse yourself, or something you're required to recuse yourself on. In terms of friends, what I will say is there's no fine, or there's no hard line, but the standard is someone who your judgment would be impaired. There are some people in your life where if they were asking for something, like, I'm gonna give it to you. Like, yeah, I know my job, like, there are some people in your life where you would not be able to remove your personal hat and put on your BZA hat. And so I can't tell you who those people are in your lives. I also, because the standard is also benefit or detriment, I don't know if you have any enemies or, I'm just kidding. But, someone who, again, you could not do your impartial duty to listen to the evidence and make that decision based on the facts and testimony. My advice would be, well, you need to recuse yourself.
I know and I'm not good friends with them, but I know who lives in these houses 4 or 5 across from me, 3 or 4 down. If a case ever comes up, I would not be a part of it.
Yep. And not just because you know them, but because, if one of your neighbors asks for a variance, they want to build a 16-foot tall fence. Well, that might impact your property values. And so, that, in addition, you may be a party in interest who could appeal whatever decision the BZA were to make. So that's where, again, because you're dealing with property and you folks live in the township, that's where things can kind of the Venn diagrams can start to get a little weird.
What happens if somebody doesn't recuse themselves?
And that situation, believe it or not, sometimes that situation comes up where someone refuses, or they say, make me. Obviously, the board can't make a member do something. I've seen situations where the other board members have felt, I think this is a conflict of interest because you've been doing and from a legal perspective, I've said, well, it's not. But there's no mechanism to truly force someone to recuse yourself. What I will say is, if you do violate the ethics laws, it is a crime. So that's something that should compel everyone to play it safe. Also, you can get, it has to be prospective, but you can get opinions from the Ethics Commission on if something really is a conflict or not. And the Ethics Commission, you could call them and kind of give them facts. If it's something, something that comes up frequently, they might have an ethics opinion that has been already issued. So that way you can say, look, in this situation mirrors mine, and it's okay for me to do X, Y, and Z. But yeah, believe it or not, there are situations where folks just say, I think I'm fine. And I get it, and it's a tough pill to swallow. Like, I get it, fellow board members don't like that, but can't force someone to recuse themselves.
But if they've committed a violation, can't the trustees remove them?
Well, and I always tell people, I'm like, listen, if you do this, it's a crime, and your fellow board members know it is. And so they can turn you in. So what do you want to do? Right, yeah, so it's like, what do you want to do? Is it really,
And my point, we serve at the will of the trustees.
Correct. Yes. And that could potentially give rise to the trustees removing someone. Board members can only be removed for a cause, but if violating ethics, that probably rises to that level.
Robert's rules apply to the BZA?
So it depends on, by law, the answer is no. The board can adopt Robert's Rules of Order. I feel like you guys follow like quasi-Roberts, because Roberts has so many nitty-gritty details, and our advice is, listen, if someone knows Roberts, great. If it impacts the order of business because people are getting bogged down in the procedure, like, I I don't know that it's helpful, but you don't have to, you don't have to.
So if we have, we've got 5 members here now, if we didn't have a quorum, because people have recused themselves, or we can't say it.
Recused.
Yeah, recused themselves, and we don't have a quorum anymore, are we still viable?
So, well, and that's another agenda topic of, getting, alternates. That's the importance of alternates, so that way if there are, and the BZA can have, up to 2 alternates. So, theoretically, 3 regular members could recuse themselves. Wait, no, actually 4 regular members could recuse themselves. And you've got your 2 alternates, and that would still be enough to get a 3-person vote. Good questions.
Can I add to
Yeah,
that?
absolutely.
If you go out to the website of Julie's firm, Pete, I'll give him a plug, he has put on general information of township meetings. And just tonight, I used one of his, it says typically a trustee will ask other trustees if there are any corrections, deletions, or additions to the minutes. I read this verbatim to you, right? If no corrections are noted, then it would be sufficient for the trustee to say, there are no corrections, deletions, the minutes stand as approved. That's why we didn't take a vote. But I knew you were waiting to vote. But again, it's just simplifying or streamlining what you do. And I have another one, and that's a good question, because I got a lot of questions on the Robert Rules. When we first met, when this group met, they've been with it for a while, you handed out a number of handouts, and I got them someplace. And there was a couple different openings and things of meetings, you know, and so first of all, to open a meeting, we don't have to have a motion to open the meeting.
No.
Okay, and I did that today, we will do that. And then one of them, you say for the chairperson to introduce the board. Should that happen? Or again, is that just?
It is, and I think I know what, I've given you kind of handouts that kind of like a hearing script.
Well, yeah, one of
type
them,
thing. Yep.
one of them has you speaking, telling the audience
Yep.
what the ground rules
Yep.
are. Okay?
So, those, again, every board does its own thing. You don't have to do that. You don't have to. Some of the handouts I've given you, there are handouts, they're not actually attached to this. We've got some other handouts. I got more papers I can give you guys of, there are wrong ways of doing things. There are ways that you can go off course, but, in terms of, order of operations and that sort of thing, it's, what works for you guys?
What things do we positively have to vote on?
Applications.
Okay.
And, continuing hearings.
Yeah.
Um,
And I think I read his thing, it's motions, what he calls motions.
Yes. Yep. And you, act by motion. And so motions document, again, that's, I move, it needs a second, is there discussion and a vote? But yeah, in terms of what actions are you taking, it's generally on the application itself, if you're continuing a hearing, and that type of thing. So, you don't need to, take a motion to adjourn the meeting. Again, it's not wrong, there are some boards that do that, but again, it could just be the chair saying, meeting adjourned. So yeah.
So if he isn't liking what we're saying, he just say, done?
Oh, yeah. Maybe not, maybe not the conduct of the board, but I've seen, again, where it's like the audience cannot control themselves, and it's like, the board just like, we are done, so.
Like the nasty school board meetings on social media.
Exactly, exactly.
Could be Whitehall City, but.
But yeah, I think, I mean, unless you guys have any other questions, happy to continue to answer questions. I think this might, is a good, transition into the remaining agenda items, cause it kind of all ties together.
Well, let's go to point number 5, alternate position for BZA. Currently, there are 3 applicants, and the position is appointed and approved by the board of trustees. Anything more, Eric, to update on that?
I do, there's now 4 applicants, and all of those were forwarded to the township administrator for the trustees to review and make their recommendation. How this came about, since I've been here, we have not had an alternate on the BCA. We have always had an alternate on the zoning commission, for at least, half of it. And, this came up in one of our work group meetings with the trustees, and all the directors are there, and, said, hey, we wanna move forward with, having an alternate on the BCA as well, so, that's where we kind of closed it out, and, it's still out there, people can apply for it, and, like I said, we have 4 now, and all of those have been forwarded over, so. They could possibly make a decision for the next meeting, I'm not sure.
Depending on how many get approved or whatnot, would they be showing up at every meeting in case of there is a recusal, someone, God forbid, gets in a car accident or whatever, or how much time do they need ahead of time for them to be here?
I generally tell everybody when I send the notices out, there's a meeting on this date. If they choose to be compensated, they would only be compensated for serving on it, not just attending.
Okay.
So they're welcome to attend every meeting, they'll be invited to every meeting. But if somebody would let me know, hey, I'm not gonna be there, then I would say, hey, of the 2 alternates, who was to fill in for me? Well, for the reason I can be available.
You know, my question, and I believe that this is the statement, I believe Tim Atkins was the alternate for the zoning commission. And I watched many times, so back his head, he and of course, he was very, very good about coming to every meeting that was ever, whether it was township or whatever. But how do we make this person a part of, and instead of somebody, well, I got this job, but I haven't went to any, you know, how do we embrace that person or bring them into the fold, as they say?
Well, hindsight 2020, probably should have, done the training when they were brought on.
Well, that's true. Well,
But
we
that's
can train
okay.
them and still not-
That's okay,
still
we
not
can
doing
train
it,
them
yeah.
again.
Yeah, that's what you did with me when I was the alternate originally.
Okay, cause we have given, we have given this before. I mean, I think you can, I mean, the board can meet when you don't have applications. So, I mean, I realistically, you know, might encourage them to show up to a couple of meetings early on, just to, again, get the feel of it, how do things run, if they have questions.
Have they seen the videos on social media of the meetings so they could see what's
Right.
going on?
Yep, they can also, they can look on social media, so, yeah, it is a tough balance, because obviously, you know, you guys, sometimes you don't meet every month, but it is important, work, if one of you guys can't make it, then, so, yeah, there's no wrong answer.
You were an alternate before?
Mhm.
How come you don't know more?
I think it was Adam, or Pat invited me in with Adam, and there was a lady that was gonna be there too, that she was gonna be the sitting member.
What's the first name?
Possibly. Yeah. But she, I mean, 5 minutes in the meeting, she says, I don't know if I can make that commitment every month.
Yeah, that probably was.
So, but we sat right over there.
But I want to make a statement. He told me that, but it's, you know, I think that this is a great, prestigious to set here, to be able to step for the township. I think it's, you know, when you talk about that, when you talk about the outside people here, it is amazing opportunity. Matt was, you know, I'm going to tell it anyway.
Go ahead.
So he's telling me, because I've got a similar story. it was when he was down in, I think it was right after he was down in Texas, getting all his awards for his work.
There's no
But he was coming back, and he's, you know, he's with the fellas, and he says, I got a board meeting tonight. They looked at him, what board have you got a meeting to?
Right,
And
yeah.
he tells them.
That wasn't at a bar.
I'm on the BZA of Linden Township, and it was like,
They let
wow, wow. And I had a similar experience at a college reunion. Hey, what are you doing in retirement? I said, well, I've been gardening, golfing. I haven't been working, but I did just little zoning work with Linden Township. And they didn't ask me about the golfing. They didn't ask me about that. They asked me about the zoning. It's prestigious, very prestigious, you know. So-
You know, you get a little
Imagine.
paid per meeting, but it's not much, and, you know, you're here because you
I've
care.
never had two W-2s before in my life. This was the first year I've had two. I've worked at the same place all my life, and it's like I got two W-2s, and I'm like, what?
W-2s.
What do I do? Two W-2s. I got two W-2s.
But it's, you know,
Three, actually, because one was incorrect, supposedly.
That's right. But it ended up with two.
Yes.
But
You're-
the whole, you know, the world has changed because of the internet. Now we recorded before, but you know, my advice to the new person was, you know, be prepared when if they get the information, read it again before you come. Don't come to the meeting. Well, you know, I just go and vote whatever they tell me. Be prepared. And you know, write down questions. Hardly anybody brings in paperwork but me. You know, be professional, be on time, dress, be internet ready. You know, because you're not representing only yourself. You're representing this township and the position. You know, and being prepared is respect for Eric, and it's respect for the applicants. I haven't seen an applicant come here yet that wasn't in here at 5:30, you know? And it's about that professional presentation that you're representing the township, and again, it's very prestigious, but I would tell them, enjoy, learn, and grow.
I think another, real opportunity is when the board is in private deliberations on the applications. I have seen new members of BZA say, I didn't know what questions to ask. You know, you guys know you know, what's going on, and so, it's easy for them to just say, like, I'm going with the flow. And I think back in private deliberations, that's a real opportunity to walk through, as you guys do, you know, the applications and say, like, well, here's kind of what I'm, you know, pros and cons, and
Little Monday
this
morning
is-
quarterback.
Exactly, and let them know, that, you know, each board member is one vote, and even if it's a 4-1 vote, you know, it doesn't have to be 5-5. It shouldn't be 5-0 if, you know, if you think the answer should be no. But that's just the other kind of thought, that, again, it's easy, I do think that, and I have had some new BZA members say that they almost need to, like, gain their courage a little bit.
You know, I thought about making a change of when we initially have the applicant give their presentation, and then we open it up for questions, is to be more pointed on a question and just go down the line so nobody gets pecked. Because this is a veteran crew now.
Yes.
I don't want to see anybody get left out. You know,
We speak up.
Yeah.
We're
well,
good.
I can tell you this, that a lot of times that doesn't happen. We've had a lot of sessions back there where there hasn't been a lot of other input. We try to draw it out, but that's the truth. It isn't making it up. But everybody has an opinion, you know, and can add. I tell you, the greatest thing is that when a diverse group of people, you know, he thinks about things I don't think about, you know, and you get really, really good comment.
And to that point, I do have some boards where, you know, the chair will start and just work, you know, any questions, any questions, any questions, so each
Yeah,
person.
You can say no,
Yeah,
but.
exactly.
but it makes, nobody gets left out. And then after that, you can do what you want, but I'm gonna start doing that.
Nah, I like pepper in them.
Well, we've had to extend, we've had to extend things because we've had different votes and stuff we didn't.
I never really thought about that, and Pete, God bless him, I remember he was here
Love you,
for
Pete.
one, and it was.
What happened?
And there was one person that was a little different, and you could tell, we didn't vote, but you can tell where they stood. And it was like, he just kind of sped things up, and said, well, you can vote no then.
Yeah.
It was simple as that. Yeah, it was simple. And I thought, boy, wow.
Yeah. If the, and temperature checks, that's kind of like, you're not making a decision, you're not making it, you can't make a decision in private deliberations, but based on the conversation, you can sense the temperature of where everyone is, and that's exactly it. It's like, okay, well, do we think the temperature is passing? Then, let's get out and tell the applicant and get everybody home.
I had a question, you guys would appreciate this. I am going to reach full retirement age with the United States government in a few months. I'm gonna get some money back. Okay?
That's what you think.
So I haven't worked for 2 years, but I live
Keep running
on
in.
investment income.
Sure.
Because certain things happen in taxes, I've reduced our income, where basically I'd say that until I got that W-2, I always said, hey, I haven't, and Uncle Sam wants to know, the last 2 years, have you worked? And I started putting down no, and it's like, wait a minute.
You're gonna get audited because of.
I gotta explain $250, okay? And I say to myself, and they wanna know your place of employment. And I really don't feel that I'm an employee of Linden Township, even at what they call an employee for a day. But what are we?
That's what you are. I mean, you get a W-2, you're not a 1099. Yeah.
You put the occupation, employee for a day.
That's exactly right.
Well, there'll be an audit.
Any other questions on alternate?
When will we know? After township, or after trustees say something about it?
That's him on my tax thing.
No, I think we're going to move on.
But we know if we get an alternate, and who's gonna be that
It
guy?
could be the next meeting, it could be the meeting after, I'm not so sure, yeah. Whatever I see it on the agenda.
Okay, last item, short-term rentals and BZA recommendations for the zoning commission.
So, you can kind of jump into it if you
No,
don't
go
mind. So,
for
but,
it.
we're working on a procedure or a policy now through the zoning commission. And it's basically gonna mirror, another township's, policy. But how we wanna move forward with that, I wanted to present that to the BZA, to say, hey, what's your thoughts on how we should do this? We could treat each one of these short-term rentals as a permitted use, so they would just merely come to our office and say, hey, I've got a short-term rental, and I live at 1, 2, 3, 4, 5 Main Street, and this is what I wanna do, and we'd say, okay, basically rubber stamp it, and give me $25 for doing it, or $50, or whatever it is, and thank you. We're letting us know.
Is it a
Change
yearly,
anything, if we do anything,
is it a yearly thing, or yearly, or for you guys?
I think it would be until it would change. I mean, it would be just that. They're out of operation for 2 years, and then somebody sells it, and they would need to reapply.
Oh, I see, just for, okay, got it.
Or we could treat it as a conditional use, which was discussed, and that's the plan that this other township uses, that's how they treat them. So it's just, I don't wanna say it's more obstacles, it's just more information, being able to gather and say, okay, here's the rules, here's how you can do it, and here's how you need to move forward. It's more of an investment, should I say. Those would be in front of the board.
Is there any tax income for Linden Township on short-term rentals today?
Today, no.
About if we put this process in place? Is that because we don't want to, or?
Or is it because it's outside the JEDs?
Well, it's not part of the JED. It also, I'm trying to think how to say this.
Western schools will get it because it's income.
They should, but, you know, I don't know.
Because that new tax rate.
I don't know.
Yeah, I don't know about the school, 'cause Westerville has an income tax, or the school district has an income tax, I'm guessing. So yeah, they probably would, because that's a business operating somewhere in their, jurisdiction. But yeah, it would just be like a home occupation. The township doesn't get additional revenue off of home occupations or that type of thing. The, short-term rentals would be a different conditional use, but again, the township wouldn't make additional money off of them.
What is the time of a short-term rental? Or is that for us to define, or the zoning commission to define?
Less than 30 days.
Okay.
Yeah. That's kind of like the standard definition of, is it short-term versus, renting a house. 30 days is the key.
What we're doing now and what, you'll be able to kind of say, here's how we're gonna, if you can have it and what the qualifications would be, we follow the Ohio Building Code. And the building code specifically says 30 days.
You're saying that's what's today?
But that's what the Ohio Building Code says, 30 days. They're referred to as transient.
Well, in that, what was that with Akron, was it Akron? Canton. That in that one, a zoning inspector goes out once a year and inspects the properties. Under our current, does anybody inspect them? No.
Because we don't even know where they are?
Pretty much. How I know of them is because I received a complaint, not because of the rental, but because of what's going on in the property. So, one was parking across the sidewalk, and that it had a trailer that had chemicals on it, and they were worried about it. So they were out of town, probably sealing driveways or something, had the tanker, parked across the driveway, or the sidewalk, was in the driveway, and that's how I found out about it. So when we go to say, what's going on, they were already out, the cleaners were there, and they said the short-term rental. Or it's a rental.
Gotcha.
So I think in terms of the future zoning amendment and that sort of thing, that's kind of working down the line. And the zoning commission, and as Eric said, the thought is to identify new short-term rentals as conditional uses. And so if anybody wanted to open a short-term rental, they would have to file a conditional use application and come in front of you to hear their request.
You're saying new, so if they're already in, you can't go
Correct.
and,
It would be lawful non-conforming, so any,
so who's to say that, oh yeah, I've been doing this for 2 years?
and that's a tough part, or that's kind of that's a conversation that, enforcement may, enforcement.
So in that scenario, the zoning, and let's assume the trustees approve, the zoning commission would draft, like Canton, I call all the definitions and requirements there would be no permit, or there would, see, I saw this, I saw what Kenton does, and I only saw the BZA getting involved when there was problems, versus, you know, there was, here's what it is, you fill it out, you permit, you get inspected.
So, and we've been looking at Canton as, a bit of a framework, not necessarily as a mirror. But the thought currently, unless, again, if BZA is wildly opposed to this, then we can take this feedback, back to the zoning commission. But the thought currently would be identify, short-term rentals as conditional uses in all of your residential zoning districts. And then, they would have to come get a conditional use permit approved by the BZA in a hearing.
What's the advantages of that versus what Canton's doing?
Just a policy decision, I guess, of, cause I thought Canton did have conditional, I thought they identified them as conditional uses.
I'm pretty sure they did.
Yeah.
That's what kind of leaned towards that one, it was just more of a, we had more control that way.
Yeah,
Yeah, and the benefit of, or and maybe this is the way to answer of, you know, why identify something as a conditional use versus a permitted use or prohibited use? And it just is, does the township want oversight? If it is a permitted use, then all they have to do is just come to the township, say, yep, I'm now using it for an Airbnb, and they're done.
Adult license.
Exactly.
Okay.
You know, conditional use, there's more oversight because recognizing that, all right, well, short-term rental may work in our community, but maybe it doesn't work everywhere, or maybe, you know, someone has a particular vision for their short-term rental that just isn't gonna work. So, again, it's just about how do you want to handle those types of requests?
So back in it, but it would be defined before within the conditional use, the occupancy levels, you know, most of these are driven off of how many bedrooms you have and how many people can sleep there. We're not doing that with every case.
Correct. So the definition, you know, there's gonna be a definition of short-term rental. The extent of that, you know, how detailed that definition is yet to be determined, because again, the zoning commission hasn't initiated that sort of thing.
That would be a zoning resolution.
Yep.
Okay.
The standards would be in the amendment.
You know, I see it as I said earlier, low volume transaction thing. I mean, this is anything much more than what we've seen with the A and B childcare.
So what is the purpose of the township wanting to really look into this or whatever, if there's no tax revenue or anything like that? Just to see who's coming and going? Cause I don't mind, I'm just curious.
I think it's just to be able to regulate what's going on and to make sure that we have some type of control over what's happening within the township. I mean, it could be,
Are you allowed to answer whether the township feels something nefarious is going on or not?
I mean, I don't know that that's even
Okay.
considered, but.
That's good news.
But there was, I think it was Bath, Ohio, I think I talked about it before, it was in Bath, Ohio, and they had a shooting or some issue occurred at this short-term rental.
You hear about it a lot.
And we're like, what if something like that, God forbid, happened here, what would we do about it? Do you guys regulate that? What do you do? We think we should have an answer, to be able to say, oh, well, here's our webpage, here's what they need to do, here's what they come in, this is how they need to apply for it, this is our rules on it, instead of, well, we follow that.
But if they don't file, like Julie mentioned, because they supposedly were doing it for
years prior before we came up with this resolution, then what happens if something happens to one of those properties?
So, I think a little research might be able to help us out with that, because it's probably a house that they flipped or they just purchased and they went for it, and I can track that down through the website. Look, this person's the new owner. Nah.
Okay.
You didn't have this 2 years ago because you just bought the property 6 months ago, or 3 months ago.
And
One
what,
thing that I got out of it, but might be, to add is, any type of resolution has definitions about what you can do, what you can't do, how many people can come here. People can disobey the law.
Every day.
That is not gonna stop somebody doing an act, or having 50
Agreed.
people over for a session.
Free
But-
will.
But what it does put in place, at least in the guidelines, is the thing that impressed me was so many contact points. You've got the owner of the property, you've got the person managing the property, there has to be, and this is the Kent case, there has to be somebody named that's on 24-hour call. It's a 24/7 call that responds within 45 minutes. At least you have some levers to pull when there's a problem.
What kind of problem, are we talking like a maintenance issue, or are we talking about a medical issue, police issue, or anything?
Probably, and I don't know, probably all the above, but I saw it as police, hey, the neighbors calling and saying, hey, there's a hell of a party over here, they got 50 people. Yeah, something like that.
So what happens, and in the, looking towards that property owner, what happens then when neighbors just band together and say, well, there's disturbance going on over there, and they do this repeatedly whenever someone else is running that house?
There's a series of escalation of violations.
But what if nothing's actually happening, they're just bearing false witness, so to say?
so something else to keep in mind with lawful non-conforming Airbnbs or short-term rentals, that there's still conduct issue, like this situation in Bath, if somebody gets shot, Glendon Township police officers are gonna come out and start arresting people, that type of thing.
Mhm.
If someone is, if the house isn't being kept up, property maintenance issues, noise resolution, that type of thing. So there are, outside of the zoning realm and zoning enforcement, there are, because realistically, that's those are the big things. Somebody parking in a way that's across the sidewalk. Well, that's not a unique short-term rental problem. That's a global problem. It doesn't matter if it's a short-term rental or if it's one of your houses. It's a problem if someone's walking the sidewalk. So that's just something else to keep in mind in terms of with short-term rentals, that regulations and restrictions that apply to everybody also apply to them. But it sounds like, again, just consensus-wise, it sounds like if the zoning commission and trustees move forward with treating as conditional use, I don't know that I'm hearing pushback or negative feedback on you folks hearing that type of conditional use application.
We're quasi-judicial, correct?
Correct.
We don't write it, we just interpret.
Correct.
Okay.
And again, it's a situation where you start to get 10 conditional use permit applications for short-term rentals a month, you can revisit, just like we've done with other variances and restrictions in the past. But, okay, Eric, any other questions you can think of?
Do you guys foresee a bunch in the beginning?
I just don't know. I think after looking it up, and I think it was maybe 8 or 10 total. I don't know that there's that many. There's a lot of little property, but there's not that many short-term rentals.
Right.
Well, my sisters run VRBOs down in Tennessee, and they have multiple houses, but they're rented out to international clients that come in for a month or two at a time, sometimes even more than that. more corporate than anything else, so. It's very profitable for them, so.
There was a definition in there that I read, it had to do, people that had cabins, yurts, and whatever, and I think they called it commercial rentals versus the Airbnb.
Occupied rental.
There's two different things.
And realistically, an Airbnb somewhere down by Ohio Stadium versus an Airbnb in London Township, it's gonna be a different clientele. Like, as you said, corporate, I know, I've had, like, you're going to visit family, and it's like, look, I don't wanna stay in a hotel, but, I can stay in an Airbnb that's, half a mile from my relative's house, that type of thing, so. But again, just making sure you can.
With all the
you can
development
hire.
going on 5 miles that way down 161, I could see someone wanting to rent their house out, short-term, long-term, whatever, to any number of construction crews for the people that are gonna be working there, because it's a very close commute.
Once they get the approval, right, do they need to tell us, like, when they get a tenant? Like, do they need to inform us every time they get a tenant, or how's that?
I think
All right.
yes,
It's a one-time deal, it sounds like.
No, yeah.
No, he's talking about, do they have to tell us every time they rent it out to
Oh,
someone?
no.
No, you do. They don't.
Would that be a yearly fee, 5-yearly fee, whatever, them registering as a short-term rental?
That's what I was asking.
I missed that, I
In
apologize.
general,
It was just a one fee,
Okay.
they can abandon it. You can include restrictions that basically says, like, if you stop operating for that amount of time, they would have to come back. They could, have to basically reapply for a conditional use permit. That's something that we can put in there.
What kind of background, because I've never done it, what kind of background checks are done on the people who rent the properties? Is that up to the property owner, or, I don't know.
Airbnb, I know Airbnb, because that's like the account, and VRBO, that sort of thing. I know people can get banned from those services, but I
Sure.
don't know that like, to sign up for one of
So
those.
something bad has to happen before they're banned, but they'll rent anyone who's willing to pay the money.
Maybe. I'm sure, I have no idea
I'm just
what their
asking.
terms of service are.
I haven't, so that tells you something.
when will we know?
I'm sure that they would have to look at something like, high school graduation's coming
Yeah.
up. Hey, you know what, let's go have a house party and rent this place out.
Yeah.
There has to be some kind of
Okay, so,
guideline for them to be able to say, okay, who am I renting this property to? Are you, like renting a car, you have to be 25. It's sort of like along those lines, to say who's gonna be there, just the number.
I'll throw out a wild hypothetical. Over in my neighborhood there by Huber Ridge Elementary, that is up close to the school or whatnot, what happens if someone comes and rents that place that isn't really supposed to be by a school or whatever? What kind of ramifications are there for something like that? I know that's probably up to them, that they should find that out, but if they're renting it and they didn't realize they were that close to school, then
I think the one in Canton had something written in there that was 400, you had to be 400 yards from the school or something. There was something that they addressed some of that. It can be written in.
But in terms of that, at the end of the day, that is, think of that broadly of like, it doesn't matter whether it's a, short-term rental today, or if it is a regular home today. At the end of the day, if certain people have restrictions on where they live, that's between them and whatever overseeing governmental authority. So I probably wouldn't, from a zoning perspective, I probably wouldn't want you guys to start dipping your toes into that. But yeah, no, there could be a scenario where someone says, there's someone rented, and, I don't know, but I do think that most of those are generally like permanent residents. If that's the key, not necessarily the fact that like you couldn't spend the night in a house or spend a week in a house that's near a school, but I'm not overly familiar.
I'm not either, thank goodness.
Not overly familiar with that, so.
I said wild hypothetical, just
Yes.
not.
No, that's fair.
I want to ask, would Eric review the house complaints before granting the short-term rental? Like,
Right now, right now, there's no, someone could just open a short-term rental.
but in the future process, right, when somebody applies, would someone check, okay, whether there been any complaints in this home, more complaints in this home, before granting them?
So, well, if someone were to, you shouldn't be getting any applications from people who are operating. You know, so theoretically, it's if someone wants to open a short-term rental, those are the applications that you should be seeing.
Are you asking if somebody's applying and the neighbors don't want it? Is that gonna be
No,
important?
no. I'm just saying, like, if some home, if there's repeated complaints,
But that's where a renewal process
Is
might
this
come
after
in
they've been
handy, where if there's been documented
Yeah.
problems from that residence.
Well, so if somebody is approved and there are complaints, then what happens? So that, they're still subject to the zoning restrictions, and, if they're violating a zoning restriction, if there's a property maintenance issue, those are mechanisms that Eric can use in terms of enforcement. Obviously, the police department can, move forward with any criminal charges, that sort of thing.
If we write, in some kind of regulations or whatever, that they have to be registered with, Airbnb or VRBO or something like that, and those organizations have stricter requirements. You know, you can be a super host and, you know, or you can lose your status. So I think maybe if we incorporate that they have to be registered as a VRBO or Airbnb or something like that.
A brand name?
Yes.
The problem, all of those things are completely fair. The potential problem I see from the township's perspective is, that means Eric is getting really far into the weeds, figuring out, like, well, are you on this site, or if Airbnb goes under, that type of thing.
Because they can list on either multiple or switch sites too, correct?
Correct.
I don't know how it works, but, okay.
But yeah, so that just adds an extra, potential enforcement. That's the concern that, or the potential flag.
We didn't have anything to do with it. We said, you know, we'll do a conditional use or something like that, you know, but you have to be registered with one of these major businesses or whatever, and those major businesses would be the ones that would be determining whether or not.
Right, if they're
But then you're
operating.
killing entrepreneurship.
No. Just keeping Eric out of having more work to do. And that's-
Kentwood did have the violations on there. Any of the following considered violation of township resolution pertaining to short-term rentals. And it's got a finding process and stuff, but I don't know about the background.
All right, more of a procedural question. You said that the zoning commission is still gonna be speaking on this?
So the zoning commission is going to, they will at some point initiate an amendment,
Okay,
and then it would go to the trustees.
all right. All right, okay. Would we, as board, be able to go as citizens, as we are property owners within the township, residents of the township, I should say, and speak our minds that way as a citizen as opposed to a board member? Okay.
What I would say is if you want to talk about potential impact on the BZA, if there's a possibility that at least three of you want to go to the zoning commission meeting, that'd be a quorum, and we don't wanna have open meetings issues, so if, there were enough of you who were like, you know, we kinda wanna chat it out in one room with the zoning commission, we could hold a joint meeting of the BZA and the zoning commission. That could be an option.
You could just not sit next to each other.
That's very true too.
Well, my questions and comments would be more of a resident standpoint anyway, rather than
Absolutely.
BZA standpoint.
then yeah, yep, nope, you are absolutely, able to do that, yep.
Okay. Thank
When
you.
will we know that's coming down?
Well,
When they make a decision, they're having a meeting tomorrow or something.
They meet next Tuesday. I think we will be initiating the amendment, but then the next step is that they'll schedule the hearing. So it would probably be, we're in April, so it'd probably be their May meeting that they, and then again, and then it also will go to the trustees as well. So 2 opportunities if you. Very good feedback.
Thank you, both of you.
Meeting, thank you. Meeting adjourned.
You take minutes.
7:56.